Let's now build the actual architecture of the federal court system, because to understand how a case travels, you need to see the three tiers clearly. At the base are the 94 federal district courts, the trial courts of the federal system. Every state has at least one. The most populous have four. District courts have original jurisdiction, the authority to hear a case in the first instance. This is where the action of a trial happens. Facts are established through evidence and witness testimony, often before a jury, while the judge manages the proceeding and rules on legal questions. Representing the federal government in these courts are the United States attorneys, appointed by the President and confirmed by the Senate. The middle tier is the U.S. Courts of Appeals, organized into 12 regional circuits, plus a 13th, the federal circuit with national jurisdiction over specialized subjects like patents. When a party loses at trial and believes a legal error was made, it appeals to the appropriate circuit. And here's the critical distinction. Courts of appeals exercise appellate jurisdiction. They review the lower court's legal reasoning. They do not re-examine the facts or hear witnesses. Cases are usually decided by rotating three-judge panels. Especially significant cases may be heard by the full court sitting en banc. At the apex sits the Supreme Court, the top of both the federal hierarchy and, on questions of federal law, the state systems too. 9 justices, the Chief Justice and 8 associates. And note, the number 9 is not constitutionally required. It's set by statute, and Congress has changed it several times. The court's jurisdiction is both original for disputes between states and appellate. Now, the most important structural feature for our purposes, judicial independence. Federal judges serve during good behavior effectively for life, and the Constitution prohibits reducing their salary during their term. Those two guarantees, life tenure and salary protection, are the structural pillars of judicial independence. A judge who can't be fired for unpopular rulings and whose pay can't be cut in retaliation is insulated from political pressure. But that independence is in tension with the appointment process, which has become intensely political. For most of American history, confirmations were routine. The defeat of Robert Bork's nomination in 1987 is the conventional turning point, after which ideological scrutiny became standard. Since then, Thomas, the failed Garland nomination, Gorsuch, Kavanaugh, Barrett, confirmations have become high-stakes battles, feeding a growing perception that the court's composition is determined by electoral outcomes and procedural maneuvering as much as by legal merit.